My name is Vera Richardson, and I am making this video to address issues of discrimination, Title VII discrimination, that will be addressed at Sotomayor's confirmation hearing tomorrow by firefighters from New Haven, Connecticut. And the Ricci case filed by the firefighters in Connecticut, they alleged that they were victims of reverse discrimination, also covered by Title VII. I, like the firefighters in Ricci, also filed a lawsuit alleging racial discrimination and retaliation in West discrimination. I also, like the firefighters in Ricci, received a summary judgment order from the district court dismissing my case. Also, like those firefighters, I appealed that dismissal to the Second Circuit Court of Appeal, the court where Judge Sotomayor currently resides, and she currently hears cases. And also, like the firefighters in Ricci, I also appealed my case to the Supreme Court once I was given a summary order, just like the firefighters, from the Second Circuit Court of Appeals. But unlike the Ricci firefighters, the Supreme Court of the United States of America refused to review my case. My position is that, and I know that the court only reviews like 80 to 100 cases, or 8 to 10,000 that's filed with that court every year. But that fact alone shows us that justice in America is not colorblind. It should be, because how many minority cases, actually minority meaning women or black or Hispanic, etc., those people that Title VII identifies as, minority within the statute, cases are actually heard at the Supreme Court. My case definitely had merit. Today, while testifying, Judge Sotomayor stated that cases where there's precedents and the precedence isn't quite clear on issues, then, and I can't quote verbatim her legal reasoning, but then those judges, have to address those issues and come to a determination. In my case, there is clear precedent set by the United States Supreme Court. In my case, after filing a complaint, one of the issues in my case is that after I filed a complaint with New York State Division of Human Rights on July the 5th, 1996, I applied for a position of supervisor of inmate grievance on July 14th, July 19th, 1996, which was 14 days after I filed my complaint with New York State Division of Human Rights. My employer, Albion Correctional Facility, was aware that I had filed the complaint with New York State Division of Human Rights. And 14 days after filing my complaint, I was denied even an interview for the position, despite the fact that I was highly qualified. I was qualified for the supervisor of inmate grievance position because I had served in that title for 2.5 years at the same facility, Albion Correctional Facility, where I applied to be reinstated. I had 3 evaluations in that title that were good evaluations. Additionally, I voluntarily left the position because I was going through a divorce and I needed the overtime that was available to correctional officers. So I went back to a correctional officer title. At the time that I left the correctional officer position, my salary as an inmate grievance supervisor was $31,000. The 12 months after I left the position, I made $57,000. And because I worked unlimited overtime, and I was willing to do what I needed to do to take care of my family. During the time that I was working as a correctional officer prior to the grievance position, I suffered 3 injuries. One injury was I fell on a cracked step, and once I fell, the supervisors, one supervisor mentioned that she knew someone would get hurt on the step. She said, and now, they repaired it as soon as I was hurt, after I was hurt. Another incident, I fell out of a broken chair on a unit, and the officer had submitted a work order to have the chair repaired, but he hadn't removed it from the unit itself. The third incident, these were all within an 18-month period. I was restraining an inmate from fighting another inmate, and I was injured during that encounter. I said that because I was also denied after my case ended with in the courts. I applied for, and after I was terminated by New York State Department of Corrections, I applied for disability retirement based on those 3 injuries. And although New York State had successfully won my case all the way to the Supreme Court, with their explanation for their unlawful termination, that I was physically unable to perform the job because of those 3 injuries, and also because of my psychological condition, which was diagnosed by my psychiatrist and their own state consultant as work-related depression and anxiety. I was denied even the disability retirement application. So although the Ricci firefighters will, and I'm not saying undercutting what they suffered, but they were still employed. They still had benefits, and they were able to get the highest court in the land to hear their case. On the other hand, my case was not even heard. My case had merit because in order to gain the summary judgment motion, New York State Attorney General's office filed 7 perjury declarations in federal court. One of the declarations was filed by the Assistant New York State Attorney General himself, and this is a copy of the memorandum of law that he filed and signed in his declaration on the penalty of perjury. And on page 23, he stated that that they offered me and they did, the position of supervisor inmate grievance as a solution to my complaint filed with New York State Division of Human Rights, and that I didn't take advantage of that offer, that I did not apply for the position. During the summary judgment process, when I filed my summary judgment motion and also a reply in response to Russo's claim and also Gonzalez's claim, affirmative action person, who stated the same thing, that I did not apply for the July 19 position, I presented to the court a copy of my resume and the letter of application that showed that I indeed, with direct evidence, that I indeed applied for the position. Despite that fact, my case was not heard or overturned. And based on the judge's testimony today, when there's a clear precedent, and in my case there is, a precedent established by the Supreme Court of the United States in Reeves versus Sander, in Reeves versus Sanderson Plumbing Products Incorporated, Judge Ginsburg, in her concurring opinion, wrote, the court holds that an employment discrimination plaintiff may survive a summary judgment motion as a matter of law by submitting 2 categories of evidence. First, evidence establishing a prima facie case, and second, evidence from which a rational fact finder would conclude that the employer pre-offered explanation for his actions was false. The explanation that I did not apply for the position was clearly false, so I should have survived summary judgment as a matter of law, and just that issue alone, even though